see. And do you see my screen? Right?
Yeah, all good.
That says Quebec Wills,
Yeah.
right?
Can I say a few words before you?
Yeah,
Alain?
sure, by all means. Go ahead.
And then Sandra will read your biography, if you don't mind.
Sure.
Okay, so you want me to start?
Okay, go ahead, Gladys, because it's 10 o'clock and we have a fair amount of material to go through.
Yeah, okay. So, hello, everybody. Welcome to the Women Learning Group of the Spanish and Portuguese Synagogue. My name is Gladys Perez Mualem, coordinator of the Women Learning Group program created by Rabbi Shahar Orenstein 14 years ago, following our celebration of Ladies' Bat Mitzvah on July 5, 2009. Today is May 31st, 2023, 11 Sivan 5783. It is a big honor for us to have Maître Alain Murad advising us about the necessity of having a will, as per suggestion of our friend, Executive Ron Mashal. We will learn the advantage of having a will and how to do it with much appreciation. We continue next Wednesday to dance with our Israeli dance instructor, Maurice Perez. We dance in our living room, following his instructions, while he dances in his living room, followed by dancers from all over the world. Please join with your friends and enjoy on Zoom to the tunes of Israeli music. We end the last session with beautiful songs and music by our Reverend Cantor Daniel Ben Lolo, celebrating the final of Series 28, Spring 2023. I would like to invite Sandra Kuku to read a short biography of Maître Alain Murad. Sandra Kuku, bevakasha, bechavod.
Okay, maybe we can dispense with the biography. It's okay, no worries.
Okay, so I am inviting Maître Alain Murad to give us his presentation. Alain Murad, bevakasha, bechavod.
Okay, thank you very much, Gladys. So we have a fair amount to go through. Wills, you know, it's a technical topic. There's a lot of law, there's a lot of case law surrounding sort of the many legal issues that wills engender. So what I'm going to do is sort of give you a very brief primer over the issues. And if you have any questions, you can just feel free to interrupt. If I'm unable to answer your questions, then I can think about it and get back to you. As I mentioned earlier to the group, I'm not primarily an estates lawyer, but I do know a little bit about it. It's not my area of expertise, but I know a little bit. Yes.
I'm back.
Okay, good.
Okay, sorry.
Okay. Yeah.
So, hold on. Just 2 seconds. Here we are.
We can't hear. We can't hear.
Can you hear me now?
No, we don't
Hear
hear
you,
you.
Sandra. We can hear you.
Okay, hold on. Okay, so here I am.
Go ahead, Sandra.
Alain Murad is Vice President, Legal and Secretary of Canadian clothing retailer Reitmans Canada Limited, where he oversees all of the company's legal requirements. Prior to his time at Reitmans, Alain was a partner in the Montreal office of Davies, Ward, Phillips and Weinberg LLP, practicing in the corporate, commercial, intellectual property, information technology, advertising and marketing, and privacy law fields. Alain also practiced in the Montreal office of Borden Ladler Gervais LLP, and with the Boston-based law firm Testa, Hurwitz and Thibault LLP. Alain is a graduate of McGill University's faculties of law and management and Concordia University's faculty of commerce. Alain also served as a law clerk to the Quebec Court of Appeal and is a member of the bars of Quebec and Massachusetts. Thank you.
Okay, thank you, Sandra. So with that,
yeah.
yeah. So with that said, let's begin our discussion. Okay, so you all know, I think, sort of colloquially, what a will is. It's something that we don't like to think about, but which we have to think about because our lives are finite, and you want to ensure that you're able to ensure sort of an equitable disposition of your assets at the time of your passing. So a will is really a legal document, right? It's a legal document that says who's going to inherit your property, right? You can't take it with you. The old expression goes, so you dispense it to people who are close to you, to your children, to your relatives and close friends. So the will is really a vehicle for doing that. It can also stipulate a number of other things. For example, who's going to take care of your children if, heaven forbid, you pass away at a young age. Your children are not of the age of majority, they're younger, then you can stipulate who the tutor of their person will be or who the tutor of their property will be, right? Who's going to oversee their assets or who's going to oversee, their personhood, who's going to help them, who's going to help bring them up. And it also stipulates who's going to be responsible for settling your succession, who the liquidator of your estate is going to be, who's going to be primarily tasked with dispensing your assets at the time of your passing. Now, making a will is not mandatory. There are many people who die in a state of intestacy, okay? So it's called, if you don't have a will, it's an intestate estate, okay? And the civil code basically provides, certain rules on the dispersal of assets based on who your closest relatives are. And we'll get to that. That's if you die intestate, you don't have a will. There are rules governing the dispersal of your assets. But it's really recommended to have a will, because if you have a will, you can sort of really specify in detail sort of the details and the intricacies and the nuances of how you want your assets distributed, to whom you want your assets distributed. Some people have much larger estates than other people. They hold, company shares in various companies. They can hold real estate portfolios. Sometimes they own, valuable works of art or valuable jewelry or things that they want to specify who they go to, right? So it's really important to have a will in that sense, because otherwise, a third goes here, a third goes there. You're not really governing who gets what at the time of your passing. Now, once you have a will, you know that your wishes are going to be respected, but wills can be complicated. And there are different types of wills in Quebec, and each one has certain conditions. And if they fail to meet those conditions, they're not considered valid. And sort of the testamentary disposition would fail under those circumstances. So we're going to get to that. So first of all, who can make a will? Well, if you're 18 and older, you have legal capacity, you're of the age of majority, and you're able to give your informed consent. So what does informed consent means? It means you can think for yourself. You don't suffer, from any sort of mental challenges or mental issues that could cast doubt on your ability to think clearly, right? So you have informed consent, you're of the age of the majority, you can make a will, okay? You don't have to seek advice from your friendly neighborhood lawyer or notary, but you should definitely do so because, as I mentioned, there's a lot of pitfalls, there's a lot of complications with wills, and you want to make sure that your wishes are going to be respected at the time of your passing, okay? If a person is under tutorship, that person, the court would basically have to determine the validity of a will. If a person is not of full legal capacity or of fully sound mind, then a court would have to determine the validity of the will if that person passes. It's very important that the person who's drafting the will is not under any sort of pressure, constraint, or threat. You can well imagine a scenario where, you know, a person who's much older is drafting a will, and you know, someone is hovering over them, telling them, you have to leave this to me, you have to leave that to me, right? So under those conditions, if you're able to prove that, to a court, if someone challenges the will, you could invalidate that disposition. All right, so before making a will, before you go through this process of making a will, you should probably prepare a written inventory of your property, right? You all know what you own. You know, most people, you know, the majority of their assets are really in a few things. For example, their home, right? That's their you know, that's where a lot of their equity resides. They may have an insurance policy. They may have, you know, hold shares in companies. Again, it really varies, of course, between the person. Some people own a lot, some people don't own so much. But it's important to make that written inventory so that you know really what you own and also what you owe, right? What your debts are, your mortgages, your loans, right? It's very important that, you know, you do this accounting, right? Because if a person dies owing more than that they own, right? If they owe more than what they have, if their liabilities are greater than their assets, and they leave assets to people, and those people mix the assets with their own assets, then those individuals can be responsible for the debts of the estate. So you have to be very careful, you know, unless an estate is what's termed manifestly solvent. There's always that risk that the person actually owes money rather than owns money. And if that's the case, and you mix the assets of the insolvent estate with the assets of the legatee, then the legatee can end up being responsible for the debts of the estate. So it's quite a pitfall. So, you know, again, that inventory is useful to people who will settle your succession. Some people, you know, in this day and age, sort of an electronic age, people have electronic IDs, passwords. They often give those they'll stipulate those in the will so that the liquidator is able to access various accounts and whatnot. If you own high value property, if you have secondary residences, it's very important to get the advice of a legal advisor or a tax advisor, because when you pass away, it's what's termed a deemed disposition, right? So if you're the last surviving spouse and you pass away, the Tax Act says, well, you know, it's like you've disposed of all your property at the time of your death. And that has huge tax implications, right? For example, you know, my dear mother, passed away in October, you know, and, you know, my eldest sister is the liquidator. So for example, she has to be very sure that there's enough money to pay off whatever estate taxes are due. So it's really important, especially if you have a complicated succession, that you seek the advice of a tax advisor. If there's a history of or a potential for family disputes, really important to consult a legal and tax advisor, because if there's infighting within the family over the estate, you are definitely going to want to ensure that, you know, everyone is properly taken care of, sort of to mitigate the likelihood that there's going to be, you know, issues between the surviving legatees. If you own property outside of Canada, it's also another complication. And you can also stipulate in the will, you know, how your body is going to be disposed, the funeral arrangements. With us, you know, these things tend to be more, you know, subject to rules, but outside of our religion, outside of our culture, people ask for all sorts of crazy things and they stipulate that in their will. Life insurance, just sort of as a brief aside, a lot of people have life insurance. It may or not be part of the succession, right? So life insurance is typically treated separately, right? It's part of your succession if the insurance policy indicates that the insurance is payable to the succession or to the estate or to the heirs or to the liquidators, to the legal representatives. But if it doesn't stipulate that, then it's treated separately. And your life insurance goes to whoever you've named as the beneficiary of your insurance policy. If you specifically name a beneficiary in the insurance policy, it's not part of the succession, okay? So if you have life insurance proceeds, you have to be aware of that, right? Because if you want it to go to a specific person and not fall into the succession, you name a beneficiary under your insurance policy. Very often it's, you know, the person who's the beneficiary of the insurance policy is also the beneficiary under your will, because it's usually a spouse or a family member or whatnot. But it's something to think about because insurance policies are paid to the named beneficiary after your death, regardless of whether the succession is accepted. It's a sort of a separate thing. Just as an aside, if you go through a divorce, typically, and you've named your former spouse as the beneficiary, then that's going to be, that's canceled, right? It becomes null. The designation becomes null upon the divorce or the annulment, unless you specifically state otherwise. In other words, if you state in your insurance policy, it's going to so-and-so regardless of whether or not we remain married or whether we're divorced or not. I'm not going to go through too much in detail. This is the obligation of support. Very often what you see contentious situation arise is when the person, the deceased, owes spousal support obligations or child support obligations, and the person passes away, right? And then the heirs now find themselves in a position where, you know, what happens to those spousal support obligations, right? So you can imagine the adult children of a man who had remarried or who had remarried and gets divorced, and at the time of the divorce he owes his ex-wife's spousal support, and then the person passes away, and now his heirs, his children, are left paying support to the former spouse, right? So that's another sort of these are sort of the issues that come up in the context of these types of wills. So, for example, if you're paying support, the death doesn't terminate the obligation, and your heirs will have to assume certain financial responsibilities for a certain period. And you know, each of these persons, the people you were supporting, may claim a financial contribution towards support from the succession within 6 months after the death. So again, these are sort of technical legal issues that come up in the context of wills, but I'm not going to get too much into it. But what's important for you to understand is that there are these sort of spousal support or other child support obligations survive, and notwithstanding what's in the will, there may the claimants of these support obligations can still make the beneficiaries of these support obligations can still make a claim against the heirs. Different types of heirs, right? So the heir is the person who you leave your money to, right? You can leave all your property to one person, a sole heir. What happens if this person dies before you do? Then what? So in your will, you can say, I leave all of my property to so-and-so, but so-and-so passes before you do, right? So who gets the estate, right? If it was all going to that person is dead, right? Then there's this, you know, potential conflict, right? An heir can be a minor child. A parent can appoint a tutor. Remember, we talked about tutorship of the person and tutorship of the property. Who's going to bring the child up? Who's going to manage their assets, right? If both parents die before the child is of the age of majority, for example, you have to make allowances for that in the will. There's groups of heirs, the use of generic expressions, my children, my nieces, my nephews. This often gives rise to these sort of ambiguities, give rise to, potential conflict after the person is gone. For example, you may state, I bequeath all my property in equal shares to my children. If one of your children predeceases you, his or her share of the inheritance will go to the remaining children that they may have. If you do not want this to happen, you must say so in your will, right? So when people are drafting these things, when you're writing these things, it's very difficult to make allowances for every possible contingency that can arise, right? You can see all these situations where ambiguities arise, right? So it's a complicated, and it's why it's really important to get really sound legal advice from people who are experienced in these types of things. And again, it really varies so much with the type of estate you have, with the nature of your assets, with what you want to do with the assets. Your spouse is typically your primary beneficiary. Your death terminates your marriage to your spouse. This entails the partition of the family patrimony, right? So you know that in Quebec, we have a legal structure called the family patrimony. So what does that mean? It means when you're married, there are certain high value assets that fall into the patrimony. And these are what are termed imperative provisions of public order. You can't derogate from them. And you can get into a whole discussion about the merits of the family patrimony. For example, your house, your RSP contributions, your pensions, all of these high value assets that are pooled and split at the time of the dissolution of the marriage. So there's this again, this rubbing up of different regimes, legal regimes between, sort of the testamentary regime governing wills and the disposition of assets at the time of death, and these other obligations like support obligations, what we talked about before, or the family patrimony. And these things try to work in concert, right? Sometimes they pull in different directions. So a partition of the family patrimony it is given priority over the distribution of property to the heirs. So you may not be able to leave certain property or amounts to persons other than to your spouse. So for example, your primary home, right, your primary residence, under the patrimony regime, it falls to your spouse, right? So you can't say, you may not be able to stipulate in your will, I leave my house to my children and take your wife or husband out of the equation, because the family patrimony says that the surviving spouse is entitled to half the accrual of the value of the home. You follow what I'm saying? In other words, if you own a house if the house that you own is worth $1 million, okay, and you pass away, and in your will you say the house goes to my children, but then the surviving spouse will say, well, no, half of it is mine legally, because under the family patrimony regime, I'm entitled to half of the accrual value in the house.
My apologies, Alain. I'm not sure if you saw my message, but we are not seeing a presentation on the screen.
You're not seeing my
No.
my presentation?
Sorry, I tried to message you, but I don't think you saw it.
No, I didn't. I wish you would have told me. Okay, hold on.
I tried. I didn't want to interrupt.
Because it says
We're
I'm sharing
just
my
seeing the screen of Rietman's, which I'm assuming is your desktop background.
Do you see this now?
Yes.
Yes,
Now you see
we
type
see.
because
Sorry, I
asked
didn't want to
already.
interrupt you. My apologies.
Well, I mean, Are you seeing this now? Do you see
Yes,
Quebec
yes, we
wills?
are.
Okay, so this was what is a will, who can make a will, before making a will, right? Life
Yes.
insurance,
Yes, we see that.
wills and the obligation of support, types of heirs. All right, so
Yes.
here we are with types of heirs. It's good you told me now, not at the end of the presentation. So at least you can see it now, okay?
Yes, we can see.
All right, so what we're talking about is the dissolution of marriage at the time of death, because that dissolves the marriage, and sort of these interlocking regimes, right, between the testamentary regime, and you have your will and you can bequeath your assets, and this family patrimony regime that stipulates that certain assets that fall within the patrimony must go to the spouse, must go to the surviving spouse. So it's interesting to see the interplay between those different sort of legal regimes. There are certain restrictions on what you can demand of your former spouse. So for example, you can't require your spouse to do or not do something as a precondition to inheriting something. So you can't stipulate in your will, you know, my assets go to my surviving spouse so long as she does not remarry. Because those types of testamentary dispositions will be null and void. They'll be deemed void by a court, because they're contrary to public order, right? So within the civil code, there are certain provisions that cannot be derogated from, right? That they're sort of etched in stone, and the state doesn't allow you to say otherwise. You know, it's a limitation on your ability to, you know, to dispose of your assets, or it's a limitation on your ability to impose contractual obligations. There are certain things that you cannot do. And there's certain things that, and this is what I was saying before, that they're deemed to be imperative provisions of public order. In other
Excuse me.
words, yeah.
Sorry, Alain. I'm having trouble reading the text. Is there any way you can make the slide itself the entire image? Because, that's already better. Because we have that, yes.
Is that
Yeah.
better?
Definitely.
All right.
Thank you.
Yeah. So, so those provisions of public order, you cannot derogate. So I gave the example earlier about, you know, the deceased bequeathing his marital home to his children and not to his wife. The wife would, under the patrimony regime, would be entitled to half the accrued value. These are things that come up. You may not require a spouse to, okay, that we said something. Divorce or dissolution of a civil union revokes any bequest to a former spouse unless you indicate in your will that you wish to maintain the bequest in spite of the divorce. So if you're married to someone and in your will you say the person gets such and such, you're bequeathing by particular title your $50 million Picasso painting, and then you get a divorce, that divorce nullifies the bequest. Unless you specifically state in your will that the person is to inherit that painting, notwithstanding whether you remain married or not. There's another interesting area where you see an interplay between the testamentary rules and it's gifts, the law of gifts. And I can tell you, gifts are complicated. It's not just sort of giving a birthday gift. There are certain types of gifts called gifts mortis causa, gifts that other people have made to a former spouse in contemplation of your death, or gifts inter vivos that you have made to your former spouse, or other people may have made to your former spouse. So you can use an example. For example, if two people are married and let's say the parents of one of the spouses wants to bequeath, wants that person, they give them a gift, right, of say $1 million, but they don't want, or they buy them a house. Let's say they buy them a secondary residence, but they don't want that gift to fall within the family patrimony. So you have to stipulate in a separate codicil that gift is exempt from the patrimonial regime, because it's a gift inter vivos. You're actually giving the individual a gift of this $1 million country house, for example. So you have to be very careful when you're doling out your assets and when you're stipulating who gets what. You have to be aware of all these things, of what happens if the person is divorced before the person passes away, if there are inter vivos gifts, if there are gifts mortis causa, life insurance, right? We talked about life insurance. You understand that there's this interplay of all of these, not necessarily, but sometimes conflicting legal regimes that may impinge on an individual's ability to distribute their assets at death in the manner in which they want to. So you have to be aware of all these things. Sorry, I'm gonna have to see if I can. Okay, people who cannot inherit. In certain cases, you can bequeath property to people that you want. Sometimes certain people in certain situations you cannot bequeath property to. So for example, the notary who executes your will, the person who witnesses your will, the owner or an administrator of the hospital or residential center if you make your will while receiving care or services there, the nurse, physician, or any other paid employee took care of you at the hospital. Do you understand why the law would impose restrictions on your ability to bequeath property to these people? Because there are inherent conflicts, right? There are inherent conflicts because the law tries to avoid situations where a person is coerced into bequeathing their assets to people who are exercising a certain degree or measure of control over that individual. So a notary is a legal expert, right? And they're very, very smart, very, they can sort of, when a person goes to them, say, I want to make a will. Yeah, well, you can leave something to me instead of paying me. You can leave me this, you can leave me that, right? Or the person who's taking care of you in a hospital and you're drafting your will because you don't think you're going to make it. And all of a sudden, you're coerced into leaving that individual, certain properties. These things have come up, right? The reason why you have these legal provisions in the civil code is because these issues have come up over the course of, sort of the evolution of the common law or the civil law, but the common law meaning, the non-statutory law, right? So these things have come up over the years, over the decades, over the centuries, and they've been codified. So again, imperative provisions of public order, you may not leave, property, a court won't uphold it. People who are deemed legally to be unworthy. Unworthy is a term of art. It's a legal term of art. So someone who's found guilty of making an attempt on your life, someone who's abused you or otherwise threatened you, hindered you from revoking or modifying your will, concealed, altered, or destroyed your will in bad faith, these people may not inherit. Unless you stipulate them as heirs after you become aware of their actions. Liquidators. If you've ever been a liquidator for an estate, the executor, liquidator, that's the person who's responsible for settling your succession. Okay, so this is someone that you trust, that probably has some degree of financial or legal expertise. Not necessarily, but often is the case. You don't have to appoint a liquidator, but it's advisable to do so. If you don't appoint a liquidator, then the task falls to your heirs. They may not agree, so they may have to petition the court to appoint a liquidator if they can't agree amongst themselves on an impartial liquidator. So the liquidator has all sorts of responsibilities. You can import more than one. And yeah, as a liquidator, you're not obliged to accept the task of liquidating the succession unless you're the sole heir, in which case you're really just representing yourself. A liquidator can resign from the task if there's a serious reason. He has to notify the other heirs in writing, and he's liable. A liquidator can be liable in their personal capacity for any prejudice that they cause, if they're negligent or if they fail in their duties. I don't know if you're going to be able to read this, but let's see. Make this a little bit bigger. So liquidator has all sorts of duties, all sorts of tasks. They have to publish their appointment in the Register of Personal Movable Real Rights. They have to make an inventory. They publish a notice of closure of inventory. They collect money that's owed to you. They pay the debts of the succession. That's a big one, right? They remember, if you got to pay off the debts of the succession, otherwise the heirs can end up being responsible in their personal capacity for the debts of the succession if they accept and commingle the succession's assets with their own assets. Income tax declarations, they identify the people who may inherit, they hand over legacies of particular title. Do you guys know what the difference is between, when you have a legacy, a legatee of particular title, it means someone who's bequeathed a specific asset, as opposed to legatees by universal title, where everyone's just, I leave all my assets to my 3 children. That's sort of universal type. I leave, my son Liam, my Scotch collection. So that's particular type. They divide the property. They remain in office. They remain in office as long as necessary to liquidate the succession. There's no specific time limit to liquidate the succession, but sooner the better. Costs incurred, right, are borne by the succession. So if there's an amount of money that's in the succession, and the liquidator has to pay off all of these costs and fees and whatnot, it comes out of the pool. It comes out of the succession pool before the remaining money is distributed to the heirs. Must get a certificate from Revenue Quebec authorizing the distribution of property, and a clearance certificate from Canada Revenue. So that's when you know that the succession is no longer on the hook for any back taxes or anything. You get these clearance certificates, and at that point, you've paid off all your taxes, you paid off all your debts, you paid off everything. And what's remaining, then people can inherit. If they don't do this, again, they could be held liable in their personal capacity for unpaid taxes, interest, penalties. And of course, the liquidator is entitled to the reimbursement of expenses. A liquidator who is not one of your heirs is entitled to receive remuneration. So if it's an heir, they don't get remuneration. If they're not an heir, if they're an independent liquidator, they're entitled to get some money. And what's reasonable, that's typically decided either in the will or by the heirs. All right. Oh, sorry. Okay, requirements for wills. Now, how are we? 10:39. Okay. How are you guys doing? Are you okay? Is everyone okay, or am I throwing too much at you? I think you're all asleep.
Excellent.
Okay.
Thank you.
Okay, so requirements for wills. There's different types of wills. Each form has its own requirements and conditions. As a testator, you must comply with the conditions of the form you have chosen. Otherwise, your will may be invalid. Okay. However, a will that does not meet the requirements of one form may be valid as another form. So, for example, a will that is intended to be a will made in the presence of witnesses, but is not signed by 2 witnesses, may still be valid as a holograph will if it's entirely written by hand and signed by you. So we're going to get to this, but all that to say is there's 3 different types. There's notarial wills, there's a will made in the presence of witnesses, and there's a holograph. Well, those are the three main types of wills. Well, if you have a will that you intend to make by witnesses, but no two witnesses sign, it still may be valid as another form of will, as a holograph will, if, for example, if you write it by hand and sign it. Codicils, do you know what codicils are? Codicils are formal amendments to a will. So in other words, you make a will, but rather than, and then you want to change something, so you have to draft a codicil. It's an interesting word. And the codicil also has to meet certain requirements. If after your death, if your will and your codicil, if there is one, have not been drawn up before a notary, they must be probated. Okay. Do you know what probation means? In this instance, not probation when you get out of jail. When you probate a will, it means you get a formal imprimatur of legitimacy by the court, right? So the court basically says, this is a valid will. We've gone through it. We've established who the heirs are. We've established that the testator was of sound mind and the age of majority and everything. It meets all the requirements of this particular form of will. And we're probating the will. It's valid. Okay. There are costs associated with that, of course. Probating a will, here we go, is a legal process that establishes that the will was in fact written by the deceased. That is, the will is in valid form. It's made available for public consultation, allows for certified copies to obtain. So that's what probating means. So types of wills. So this is an interesting exercise. What are the different types of wills? Well, the first one is a will made in the presence of witnesses. Okay. A will made in the presence of witnesses is a document you can draw up yourself by hand or using a computer. You can have someone else prepare your will for you, so long as it's not one of the legatees and they have no interest in the will. You must declare in the presence of two qualified witnesses of full age that the document is your will. You don't have to disclose its contents, but you must get them to sign your will. So, and both the witnesses have to sign the will, okay? And they must also sign initial each page of the will in your presence. And they cannot have any interest in your will. In other words, you can't have them as heirs. If the will was prepared by another person using a computer, you and your witnesses sign and initial each page. And you have to make sure that someone actually knows that this document exists, because it's not a notarial will that's sort of registered in we'll see with a registre, but it's sort of sitting there. It could be sitting there in your desk drawer. If nobody knows about it, then no one's going to act on it, right? So when you do holograph wills and wills made in the presence of witnesses, it's important that you really trust the person who's keeping your will, who knows about it. You can contact a notary or a lawyer, and they'll register a notice with the Register of Testamentary Dispositions and the Chambre des Notaires. But it's really important that when you do these sort of personal wills, that the witnesses are in good faith, that you trust them, that they're aware of your will, because if you predecease, someone's got to know about this document, right? And like holograph wills, wills made in the presence of two witnesses must be probated. Remember, given the official imprimatur of the court. A holograph will is the simplest form of will. It consists only of a few lines. A holograph will is only valid if you write it by hand and you sign it yourself. Can't use a computer. You must write the will by your handwriting and you must sign it yourself. That's a holograph. It's preferable to date it. If you've made several wills, it makes it easier to determine which is the most recent. You do not need a witness because you're writing it out yourself. Remember, it can't be done by computer. Again, if you're making a holograph will, you're the only person that knows about the will. So make sure there's someone you know, who you trust, who's going to keep your will. Again, you can also contact a lawyer or a notary. Costs of registration and probation have to be borne by the estate. I know this is going to be hard to read. Not much I can do. But this is the will that all of you have, okay? That all of you should have. This is a notarial will, right? A notary. You go to a notary for a bunch of things. When you want to sell your house, when you want to buy a house, when and a will is a big part of the notarial functions. Okay. A notarial will is drawn up by a notary. It's made in the presence of a witness, generally provided by the notary. The will indicates the time and place it was made. Once it's been prepared, it's read to you by the notary, so you're sure you know what it reflects. It must be signed by you, by the notary, and by the witness in each other's presence. When you choose to make a notarial will, you receive advice from a legal professional who can help you avoid errors that could create difficulties for your heirs. Okay? So the professional can also give you advice to help you optimize your will. They can give you tax advice, fiscal advice. It's very difficult to challenge a notarial will since the notary checks your identity, your capacity, your free and informed consent, and he makes sure that the will meets all of the conditions that are required by law, so it can't be invalidated on that basis. He keeps the original wills. They have their own archive of notarial wills that they keep, so there's not much risk that you lose it. Your legatees will be sure of finding the will when you die. Notaries are required to register all of notarial wills with the registry. It does not need to be probated, right? So remember before, in the case of witness wills and holograph wills, you got to get them probated by the court. Notarial wills do not have to be probated. So that saves money and time, but of course you got to pay the notary for the will. But it's a worthy investment, and for all of you, if you take one thing away from this, because I'm throwing a lot at you, and it's a complicated topic, get a notarial will. Don't write out your will by hand and sign it. Do it right, do it properly, pay the money, so that, God forbid, when your time comes, your heirs are going to, they'll be protected. Your assets will be distributed in a manner that, that's going to mitigate the likelihood of any issues arising. Okay.
Can I ask a question?
Sure.
I have a will that I signed with a notary 2 years ago.
Okay.
I would like to add a very little something. Do I have to go back to that notary?
Yeah, we're getting to that. We're going to get to how to amend the wills. In fact, it's our next slide. Okay.
Thank you. Thank you.
So how do you amend a will? Right? How do you add a little something to the will? Right? You can amend your will or replace it entirely as often as you want to ensure it reflects your last wishes. Right? You can amend it after separation or divorce. Only your most recent will is valid and will be implemented once it is probated. So you amend a will by virtue of what's termed a codicil. It's an interesting word. A codicil is an addition or change made to your will in a separate document. Okay. The document containing the codicil must meet the same conditions as the will in order to be valid, but it may be in a different form from your initial will. So a holograph codicil may amend or change the conditions of a notarial will. So if you wanted to, but don't do this, but if you wanted to, you could technically write out and sign and have a codicil in a holograph form that amends your notarial will. But don't do it that way, and I'll tell you why. Because it's going to be separate. It's much safer to go to a notary and have him draft the codicil. That way your codicil is in the same form as your will, and it's registered with the registry, and it goes through the same formalities. It doesn't need to be probated. Nobody can challenge it. You follow? So if there's something that you want to change to your will, and it's not a big enough thing that merits redrafting your will in its entirety, then you contact your notary and you say, I want you to draft a codicil for me, and this is the change I want to make to the will that I made with you 2 years ago. And you'll go through the same process, and what you'll end up with is a document that amends the will, but that's in the same form as your previous will. Okay? and that's valid, that doesn't need to be probated, and that you've received advice on, right? But technically, you could amend that notarial will by drafting a holograph codicil yourself in your own handwriting and signing it. But then you have to probate it, and it can be challenged. It has to be drawn up very carefully to avoid interpretation issues arising from the revocation of parts of the previous will. Sometimes it's generally better to draw up a new will rather than amending, but that really depends. It really depends on what it is that you're changing. A codicil is read alongside the will it amends. People will see what you had written previously and what you have changed. This could lead to arguments, but again, if it's in a valid form, it's been notarized, doesn't need to be probated, very difficult to challenge, okay? If your codicil has not been drawn up before a notary, they must be probated. And again, that causes complications. Almost done, folks. Revoking a will. Sorry, see if I can make this bigger for you.
Are you going to talk about the living will?
I don't have a slide on that, but that's something we can, that's an interesting point. Truth be told, I didn't think of that, but that's something that you can stipulate. I mean, if you want to just sort of take a brief tangent, living wills are also documents that where you can stipulate, you know, what happens to you in the event that you're incapacitated. You can appoint a tutor over your person, right? It really depends on the extent of your incapacity, right? Because there's different levels of tutorship under the civil code. So if someone is fully incapacitated, you know, a person, you know, the individual who's taking charge of you has, you know, pretty much power to do anything over your estate, over your assets. It really depends, but I haven't done it. But it's something when I go and I mean, I have my will. I drafted a will back in the day when I was at Davies, but I want to change it and get a new notarial will, and it's something that I would make allowances for in your will. If you should, you know, granting a person a formal power of attorney over to manage your assets and things like that, if you should become incapacitated, it's an important thing to have. In Canada, also because we're the euthanasia capital of the world, we kill off everybody. The government sanctions, you know, killing people. You know, you can stipulate, you know, whether or not you want to remain on life support, if you know, all sorts of issues to do with assisted suicide. There's a lot of things that you can stipulate in a living will, but that's something that you really should do with a notary. I haven't really delved into it, but it's something you can ask your notary about. You can revoke a will. You can revoke it wholly. You can make a new will. You can revoke certain parts of the will. Partial revocations are dangerous because it forces the liquidator to determine, you know, the compatibilities and incompatibilities between the two documents. The best way to revoke a will is to clearly state that the previous will was revoked in the new document. So if you wanted to revoke your will, rather than drafting a codicil, if the changes are big enough, then you just revoke a will and make a new will. And in the new will, you stipulate that your previous will is revoked. Again, the revocation has to be in the same form as a will. The chosen form must be made in the same form as a will, but not necessarily as your will. But anyways, if you're going to revoke a will, you got to go through the same process. You go to a notary, you stipulate in the notarial will, the new notarial will, that the previous will has been revoked. What happens if you die without a will? So these are, sorry, I'm just trying to fit this all on the screen. I don't know. So what happens if you die intestate? If you don't have a will, you die intestate. So there are certain provisions in the civil code which govern the liquidation of the succession. And it's known as a legal succession or an intestate succession, okay? In this case, the heirs perform the liquidator's duties jointly. You can't appoint a liquidator for an intestate succession, right? Because there's no one, you don't have a will, right? So in a legal succession, the people entitled to successions are the spouse to whom the deceased was married or joined by civil union, and the deceased's blood relatives and relatives by adoption. So if you leave us, if you pass away and you have a spouse and children, your spouse is legally entitled to 1/3 of the succession, and your children is entitled to 2/3 of the succession. If you have no children, but are survived by your spouse and parents, 2/3 goes to the spouse, while 1/3 goes to your parents. Siblings don't inherit. If you have children but no spouse, the entire succession goes to the children. So there's this table that I put here. This again, this is just if you pass away without a will. So if you look at this, sorry. If you have children but no spouse, right? Everything goes to the children. If you have children and a spouse that survive you, 2/3 go to the children, 1/3 goes to the surviving spouse. If you don't have children, but you have a surviving spouse, everything goes to the surviving spouse. If you have no children, a surviving spouse, and a father or mother, 2/3 goes to the surviving spouse, 1/3 goes to the father or mother. And you go through this process where you have all these different contingencies of who's left alive after you've died. And this again, this is intestacy. This is if you don't have a will, this is how the state deems that your assets are going to be dispersed. Can get very, very complicated. Nieces and nephews can even inherit under certain circumstances, but I'll leave that with you. Rapp and Rapp is an excellent notary. Robbie Rapp is my good friend and someone I've known for many, many years. And I would highly recommend that if you're looking to make a will, a notarial will, you contact Robbie Rapp. I'm sure Salas is very good also. And again, it's up to you, but Robbie Rapp is the individual I use. And if you go there and you say that we want to make a will, just mention that I recommended him. He's an excellent notary. So I know I threw a lot at you, a lot. Wills are complicated. It's a complicated thing, but it's a very necessary thing. And I would highly recommend that for all of you, if you don't have a notarial will, that you get one. And on that happy note, ladies and gentlemen, if there are, I will leave it up to you if you have any questions.
Thank you so much, Alain. It looks you really worked hard on it, and we appreciate that very much. So many details and so many things that we learned.
It's complicated. There's a lot. It's not something that I can convey to you in a couple of slides. There's a whole massive body of law. I remember when I took my successions course in law school some 20 years ago. I mean, there's so much in there. You can spend because of the interplay with tax law, the interplay with family law, the interplay with the law of persons, the interplay with the law of gifts. It's like it's all this legal amalgam of different ideas and things like that. And it's a very interesting and a very complicated area of law.
I would like to ask personal questions. I have a will already from the 80s. I did with my husband. And we just wrote, if anyone passed away, we leave everything to the other. And if we both passed away, equally to our 2 children. Then when my husband passed away, I contacted the notary. They told me I don't need to touch it unless I want to do changes. Is that reliable, that
Yeah,
answer?
you see, the thing is when the way I haven't read your will, but and you, I know you know I haven't read your will, so I'm speaking sort of in out of context. But when you have a spouses and one of them passes away, right? The only way you can escape sort of the estate taxes is by leaving your entire estate to your surviving spouse. Okay, so when you leave your entire estate to your surviving spouse, you get to delay sort of the tax consequences, right? You didn't have to pay taxes on your estate when your husband, God rest him, passed away, right? Everything devolves to you because there's a loophole in the Tax Act that basically says that if the estate devolves to the surviving spouse, you can delay paying the estate taxes. So now you own the entirety of the estate, right? When you pass away, Smallah alayki, God love you, Allah tawal amrak, as we say, your estate is going to go to your surviving children. At that point, your surviving children as heirs to your estate are going to have to pay off whatever debts you have and whatever taxes are attendant to your estate. Okay, so you're going to have to. You don't need to touch the will, right? Because basically, it's still going to your 2 children. The only time you'd have to touch the will is if you either want to, God forbid, disinherit someone, right? Or if you wanted to, if you have legacies by particular title. For example, that nice fan behind you, if you wanted to leave that particular fan to one of your children, you would have to stipulate that in your will. Otherwise, it devolves to both of them equally and they can figure it out, right? When my parents passed away, they had a very simple will. They just said, well, everything goes to the children equally. That was it. Now, I don't know what else. The only things I'm not really getting into arguments with my siblings over who gets what. I mean, right now we're just trying to empty out the apartment and do all of these things. But in certain instances, it does become contentious. If there's really valuable property, there's a lot of infighting between family members to sort of have this sort of universal succession where everyone gets things equally is going to lead to a huge range of conflicts. You have to be really careful. It's so personal. It really depends on the nature of the individual and how much money you have, quite frankly, how valuable your estate is, right? Because if there's a lot there and the kids don't get along, you're going to want to make sure that everything is really divided properly, and you have, for those assets by particular title, you're going to want to stipulate, my daughter gets my collection of this, my son gets my collection of this, my grandson, it really depends, right? But you don't have to touch your will in answer to your question. I don't think you do.
Okay, thank you. This is my question. Anybody has any question?
Yes, I do.
Yeah, go ahead.
Alain, does any influence from Jewish law seep into the way you see your daily work? Do you have conflicts with Jewish law and the Quebec civil law, or do you ever see that?
It's funny when we read the parshas on Saturday, on Shabbat, some parshas are very legal parshas. They talk about different rules in different situations. It's astonishing, to see how much of the civil and common law is based on these halachic principles.
Wow.
And it's very interesting. You can actually write, you can do a whole dissertation on it. I mean, many people, written articles on it. But there's those underlying rules. I mean, even the appellate court structure is in the Torah. This idea when Moses divides, people, and you're this group, and then this group is going to appeal to this group, and like the whole thing, it's really quite fascinating. And I always tell Fred Balboul, because we always have interesting discussions about these issues. If I see something, I'll say, well, this is what the civil code says, and this is what the Torah says, and a lot of it is based on it. I had a Lubavitch friend of mine who was in law school with me. His name was Philip Smoke. He has his own practice, and we would study, civil liability, contracts, private property, all these issues, and he'd say, okay, this is what the civil code says. The Gemara says like this. This is what this is. And there's a lot of similarities. I don't see any conflicts.
Okay.
I mean, I don't know enough about halachic law to see conflicts. I mean, conflicts come up in the, I mean, sometimes the Torah talks about very harsh punishments for certain things that wouldn't fly in a civil regime.
But like euthanasia, that's not condoned by halacha.
Yeah, so I got to tell you, I mean, that's a whole separate topic, because with the assisted suicide laws, with the MAID, M-A-I-D, assistance
It can
in
get
dying,
hairy.
well, I mean, right now it started off, the way the law evolved. When I was in law school, the Supreme Court pronounced on certain instances, for example, it wasn't illegal to remove life support and allow nature to take its course and the person pass away. But it was illegal to actually administer life-ending medications. Now, it's very legal to administer life-ending medication. And even in instances where the person is not necessarily suffering, not even dying, right? I mean, people can simply voluntarily want to die. And the way the law is evolving is that the government is sanctioning this. Okay, we'll kill you.
I took note when you were saying in your presentation, this is the killing capital of the world.
It is. We are the euthanasia capital of the world. No other country has more liberal assisted suicide laws than Canada. It's nuts.
Ya Allah.
Yeah, they're completely nuts. They've gone bazonkers. I mean, why is it the government's, duty or moral obligation to kill off its citizenry just because they're unhappy? I mean, this is crazy. What's going on now is crazy. Anyways, I'm not an expert on this, and I haven't delved into that. I find it too depressing, to be quite honest with you. But it's very, very liberal, very, very liberal.
God bless you.
Yeah.
How often you
Alain,
have to change your will?
it's Albert Triskovich here. According to halacha, my understanding is that a firstborn gets 2/3 of an inheritance.
Yeah.
What prevails, civil law or halacha in this case? Can you enforce halacha?
So that's interesting. If you have two children, a firstborn gets 2/3 and the second child gets 1/3.
Yeah.
Okay, so there you go. So that probably, if you die intestate, well, first of all, if you have a will, you can stipulate who gets what. But if you die intestate and the person doesn't have a spouse, then it would devolve equally to the two surviving children. So there wouldn't be a division, an internal subdivision between first and second born. The estate would devolve to the surviving children in equal measure.
So then civil law would prevail, not halacha.
Well, I mean, where do you live? Where are you living, Albert? I mean, you're living in Quebec, not in Egypt 2,000 years ago. I mean, yeah, of course. Of course,
But,
civil law prevails.
But the Hasidim could make the argument that according to their
Well, I
religion,
mean, what they do internally, I'm just saying that if you have a surviving, hypothetically, a surviving child can raise an issue legally, it probably would never happen because, for various reasons, one being they'd be ostracized from their own community. But I don't know if it happens in the context of, there are certain measures that you could take. You could simply have a will that says my first child gets 2/3 of the estate. But if you die intestate, then the rules are it devolves equally if you don't have a surviving spouse.
okay, thank you.
Okay, I have a question. Can you give us an idea of how much it should cost to do a notarized will and also the cost of a codicil? And before you answer that, I wanted to show that there's this booklet, the Notarized Protection Mandate. It used to be Le Mandat d'Incapacité, where you actually write out how you would like things handled in case you're no longer mentally or physically able to handle it.
Yeah, that's right.
And I put in mine, I do not want MAID, medical assistance in dying.
Yeah,
So,
yeah. Well,
so
it's an interesting
cost.
document. There's a lot of online resources that you can look to that really provide you with a lot of information. As for your question, how much did it cost? Really, I don't know how much Robbie's going to charge me for a notarial will. It'll probably cost you a couple of grand, I would say.
Really? Wow.
Maybe
And a
1,500.
codicil?
It really depends. I mean, it's hard to answer these questions because I really don't know. Maybe 50, maybe it will be like $1,500 $1,500. I'm not really sure. I haven't done a notarial will, and I really need to because I'm at that age where I better. I mean, I don't think, God forbid, if my kids would have any issues, but
Can you give us the number of
Maybe
Robbie
sometime.
Rapp?
yeah, it's right. Okay, I put it up previously. It's 514
Oh,
514-842-8183.
thank you.
514-842-8183. He's in Westmount Square, and you can call him and just mention that I gave a presentation on wills and I recommended him.
Absolutely.
He's an excellent notary.
I have a
Can I
question.
ask a
from Shelley.
question,
How
please?
much would a codicil cost?
I think it would really depend on the nature of the codicil, and you're paying an hourly rate, right? So I mean, I don't know. I don't know
Yeah,
what his hourly rate is, but it's not, none of this is cheap. But you know what? You can look at it like this. It's an investment to ensure that your will is going to be carried out in accordance the way you want it to be, and your kids are going to be protected, your heirs are going to be protected. So it's money well spent. Everyone should do this. Really, they should do this. It's not wasteful, it's not prodigal. This is an important thing to do.
I would like to ask a question, Alan. What if somebody owes on his card thousands of dollars and he passes away, and the heirs they can't afford to pay back? What happens?
Well, you can refuse an estate if it's manifestly insolvent. The heirs don't have to accept the estate. In which case the assets are going to be distributed to the various creditors, I would think. And there's a priority of creditors. I don't know whether or not the car company is going to get the full value. It's almost like a bankruptcy, right? I mean, if a person goes bankrupt, there's a distribution, liquidator comes and they distribute the assets to the various creditors. That's what would happen, I would think. But what my earlier point is that if those heirs take from the estate and they commingle the estate's assets with their own assets, then they could end up being liable for that amount of money.
Thank you.
So, yeah, but I mean, they'd be a creditor. The car company would be a creditor that would have to be, their debts would have to be settled before, you would get a certificate of clearance and all these issues.
Okay, thank you.
Can I ask a question? It's Lily Bilbul.
Oh, hi, Lily.
Hi, I know you're so smart. You love
I don't-
Freddie more than me.
I don't know how
are you?
smart I am, but
Yeah,
yeah.
very smart. Thank you. One question. Is it true, like if you have 3 kids and you say you mention them, like you don't want to give to one kid, you do have to mention his name or her name and say like $1 goes to them. Is that true? So that you didn't forget your third, like you want this
Well, I mean,
child not to be part of your inheritance.
Well, I suppose that you wouldn't, you could stipulate in the will that they get nothing. Or I'm not sure how that would be handled. I would think that in the will, in a notarial will, you would say, child 1 gets this, child 2 gets this, okay? And that's the entirety of the estate. In which case the third child would effectively be disinherited. I don't think you need to proactively stipulate that the third child gets nothing or that they get a nominal amount. I mean, but I'm not sure. I would think your notary would be able to tell you, but I would think all you would have to do in the will is to stipulate that half of my estate goes to child 1, half of my estate goes to child 2, child 3 is out of the picture.
But they can challenge the law saying, oh, they forgot me.
Well, so maybe that's one of the reasons. Maybe you specifically stipulate in the will that the third child gets nothing.
Yeah. Okay. Thank you.
That's why, because going back, it's dangerous to say, well, my estate goes to my children. You sort of use these vague, ambiguous terms. That's the type of thing that could lead to the type of uncertainty, especially if the will is not a notarial will. Right. If it's a holograph will or something like that.
Alan,
Okay,
Alan, I put in the chat a question earlier, but I guess it wasn't picked up regarding the liquidators. Sometimes a liquidator could have such a heavy job, he or she might need more than one person to handle the estate. Can you have more than one liquidator?
Yes. You can appoint multiple liquidators.
Okay.
In fact, larger estates will have multiple liquidators who tend to be professionals or have expertise in particular areas.
Right. Okay. And they cannot be remunerated, I suppose.
If they're heirs, they're not entitled to ask for remuneration. If they're not heirs, they can ask for remuneration.
Okay.
Remuneration.
Okay. Fair enough. Thank you.
I would like to mention that was a great presentation. And
Okay, well, thank you, ladies. Thank you.
Alain, can I
think you
make one
covered them quite a bit.
request? Would
Yeah.
you be able to send a copy of the presentation, the PowerPoint?
I can send you a copy of the PowerPoint. I'd rather you didn't distribute it if you want to post it somewhere, because I'm looking to various online materials and I'm kind of cutting and pasting and putting things together. It's a derivative work, but I don't know whether the underlying work is
I
copyrighted.
understand. We had a particular request from somebody. Maybe
no, there is no need, excuse me, there is no need because the session is recorded. and
right,
it
but
will
we didn't have the
on YouTube,
presentation
and
for.
it's the same link as always that I am putting it in every email.
Right, Gladys, but we didn't
Bravo,
have the
Gladys.
PowerPoint.
I wouldn't pin
on
him down
YouTube.
to such, it's not fair.
Okay, all right. I'll circulate a copy of the presentation.
You don't need, it's
learning group.
recorded.
Gladys, but we didn't have the PowerPoint shown.
Because Gladys at the beginning, I wasn't sharing my screen properly and they didn't pick up on the initial, but the other
Yeah, the
slides
rest
you
is
should have seen.
recorded, no problem.
It is recorded and in a few hours.
Gladys, everything is recorded, but we were not seeing the
It's okay,
presentation.
Gladys, don't worry about it.
Don't
It's
worry.
okay, okay. Okay, folks,
Thank you very much, Alan. It was excellent.
okay.
Thank you.
My pleasure.
Thank
Wish
you,
you all the
Alan.
best.
Thank you, Alan.
All right, all the best.
Thank
you.
Thank
Be
you
well.
so